Good afternoon, everyone, and welcome to this third and final session of our digital forensics training. We've had first two sessions. The first one was on digital evidence. How do you present evidence that is of a digital nature? How admissible is it? How authentic is it? That was our first training. Then the second training, we looked at the process. The process of looking at the digital forensics process, standards for digital forensics. We looked at digital evidence and good practices in digital forensics. Today, we are going to look at the third session. This particular session will look at handling with expert witnesses in court. How do you, for example, deal with an expert in digital evidence when you are in court? Do you run out of questions? Do you run out of things to say as a lawyer? Or, will you be equipped enough to easily handle an expert? And I'm happy our expert, who is also trained in law, he is currently undertaking an LLM, will be taking us through this third session once again, Mr. Lawrence Dinga. I'm happy to report that the reviews we've gotten so far are really, really good. And advocates across the region, not just Kenya, are really happy about this area. It's an emerging area, and it's a really interesting area. And welcome once again. I will like to introduce or to bring on board the chair of the branch, who is the co-convener of this session, and who will also moderate throughout the 2 hours ahead of us to make his opening remarks and officially welcome our expert trainer to take us through this session. Mr. Chairman, karibu sana.
Thank you so much, David. Good evening, good afternoon, sorry, ladies and gentlemen for Nairobi branch and those who are joining us from across the borders. We today here for our final session on the digital forensic. It's been quite an exciting journey, quite an illuminating journey. And I think today should be the highlight of all, because as lawyers, we are either going to interact with the digital evidence at the time of prosecution, that is presentation of the evidence, or interrogation of that evidence. So everything that we have been learning gears up and was gearing up to this crescendo, where then we'll be looking at how to interact with that evidence when you are on the other side. And there can be no fitting way to conclude this very, very exciting discussion than to look at how we interrogate the same by way of questioning the experts who have presented that report. Out of my own experience, I have noticed that sometimes it is very, very difficult for us as advocates to cross-examine experts on the other reports, because on the reports that they produce, because it basically means that you must enrich your knowledge to a level where you are able to intelligently challenge some of the conclusions and recommendations that have been made by the expert. And I think given what we have learned in part 1 and part 2, I think we are now adequately equipped to understand the concept of digital forensics, and we should be able to cross-examine any expert when they have presented their reports. Understanding also how to cross-examine an expert is also useful to those who are prosecuting, because then you are able to know which are the areas which your opponents will be looking at, and ensuring that they are well covered up during the testimony in chief. So Lawrence, of course, our gratitude for the first and second session. As we have said, you know, now this is, we are your convertees. We now want to worship at your altar. And so therefore, we welcome you again. Thank you so much for making time to share your experience with us, and we look forward to the next session. As usual, Lawrence will make his presentation, and then there will be an opportunity for a question and answer after he is finished with his presentations. Your questions, you can post them on the Q&A or in the chat, and then we will tackle them during the plenary. And if you have something that, of course, is also burning at the end of the day, at the end of when we are in plenary, you can put up your hand. Myself or David will give you the opportunity to ask your question. So let us enjoy this ride. Lawrence, take us through now the next presentation. Thank you.
Thank you very much for the introduction, Chairman. Hello, everybody, and welcome to this third part of our three-part webinar series on digital forensics for legal professionals. Let me just share my screen. Yeah, so today we are going to look at part 3, dealing with the expert testimony in court. This is, I'm talking from the technical point of view, whereby you as the investigator, you've investigated the case, you've done your report, and now you are called in court to go and defend your report. So my presentation is going to be confined to the technical, to the expert witness in terms of digital forensics expert testimony. Now, for those who are joining us today, I just would like just to introduce myself again. My name is Lawrence Dinga. I'm a consultant in the areas of cyber forensics and cybersecurity, and as well as I'm as an ICT professional, having gained almost 20 plus years in technical consultancy and in ICT. I'm a trainer at the same time and a presenter in many of the cybersecurity and digital forensics courses at an international level. And currently, I also consult with the Cybercrime Program Office of the Council of Europe. And now what I do there is I train judicial, I do judicial training on cybercrime and electronic evidence, and at the same time, law enforcement training on cybercrime and electronic evidence. I'm also cybersecurity and digital forensics expert witness in court, and I've been called in numerous occasions to go and either present my report in court and defend it, or sometimes I find that an attorney or a defense lawyer has been served with a report, and they want me to go and look at that report and then present a counter report in the court of law. So I do both. I've done from the prosecution side, and I've also done it from the defense side. Right now, I have a case which is which was supposed to be presented yesterday, but it was not. But just to tell you that yes, this is what I do. So if any of you has got any case which is touching the admissibility of digital evidence, please always contact me. I'll be able to guide you through. I'll be able to help you with the questions on cross-examination and things like that. Now, qualifications, I have masters in forensic computing from and security from the University of Derby. I'm also a certified information security professional, and I have a diploma in law. The reason why I went into law, some might also ask why you are a technical person and why do you have to go and do law? I find that most of my work, they have to end up in court. So I had an interest of making sure that I'm also conversant with some basic knowledge in law. So I have a diploma in law, but I'm not a lawyer. I need to clarify that. And I'm also pursuing LLM in ICT law from the Open University of Tanzania. Currently, I'm almost through. I'm just doing my dissertation, and then I'll be through with that. Now, today's agenda is about expert testimony in court. As a forensic expert, you've done your investigation, and now you are called to go to court and present and defend your report. Now, today we are going to discuss the role of digital forensic expert in the judicial process and how they can assist the trier of fact in understanding complex scientific and technical issues around digital forensic process. This is a new discipline. So you don't expect that many lawyers or prosecutors or judges understand it. So you as an expert witness, you are going to help them clarify some scientific or technical issues, which is around what you are doing, which is digital forensics. Now, we are also going to look at some overview of basic rules of evidence and how they relate to expert and their testimony. Then lastly, we are going to discuss some of the forensically validated court cases that have set significant relevance as pertaining to experts and their testimonies. So it's going to be a little bit short session, I hope so, but let's see what comes out of it. Now, let's start by looking at what different kinds of witnesses that may appear in court. We have a character witness. This is a witness called to testify about somebody's character or reputation. Then we have court witnesses. That is somebody who is called by the judge to testify, and usually they want the judge wants just to resolve a conflict in something in court, and so they call this court witness who is called by the judge. Then we have lay witnesses, a witness that does not just testify as an expert. This type of witness is limited testimony that is based on first-hand knowledge and their testimony, and must be helpful in clarifying the testimony or determining facts. Then we have the eyewitness that is bringing observational testimony to the proceeding after after having seen alleged crime or facet of it. Then the person that you are going to look at today is the expert witness. So who is an expert witness? Now, an expert witness is a witness qualified by knowledge, skill, experience, training, or education that can provide scientific, technical, or other specialized opinion on a fact or issue. So it is different from other types of witnesses. This is somebody who has got knowledge on a particular area, scientific area or technical area. So as such, the role of expert witness is to assist the court to understand the evidence before it determines the fact in issue. What happens is that if something, especially these issues that are involving digital evidence, now this is scientific. The investigation revolves around scientific procedure. Now, the scientific procedure that you use to do the investigation and come up with a result, these are not something that can be understood by any layman. So it is you who is going to go to court. If you are on the prosecution side, you have your report that you are going to represent to the court, And in this report, you're going to make sure that the court understands what this evidence means, and so that they can be able to determine the issue before them. So they do that by giving their opinion on matters that are foreign to the court, which means that what you are going to do, you are a special person into the court. You are an expert in the court. The matters that you are going to help the court to solve are special and cannot just be done by anybody. So for a person to be an expert, he must be deemed to be competent. You must be competent on what you in what you are doing. So an expert witness is somebody who is quite different from other experts, and what must come out clear is that you possess knowledge that not every ordinary person has, and your testimony that you are going to give to court is going to help the court in determining an issue before them. Now, qualification, how can we determine the qualification of an expert witness? So the issue of qualification of an expert witness has raised a controversy as to whether academic qualification or practical acquaintance can render one as an expert. This is something that is an issue right now. Now, the qualification of an expert was clarified in this case, Gaderu and Jaguara versus Republic. Now, in this case, the accused was charged with unlawful possession of a firearm, and a police officer gave evidence. The police officer who gave his this evidence just described himself as an inspector of police in charge of CID office at Nanyuki, but he did not tell the court how long he has perfected in his duties, whether he has been able to examine weapons that are handmade, not just the ones that they normally collect during the operations. Now, what came out clear with this in this case is that the judges determined that the expert skill is not confined to knowledge acquired academically, but also includes skills acquired by practical experience. So if it's a police officer who has been doing this thing for a long time, or is been employed on operational or investigation work, then we can deem this person to be an expert. However, in court, if you are on the defense, still you can query this person and go into detail, especially in forensics, go into details to try to cast doubt on the competence of that person. But in general, you find that prosecutors or the guys who do investigation and they bring bring it to court, when they are being cross-examined, you find that most of them, why these cases fail is that they don't actually understand how to investigate, how to preserve, and how to present digital evidence in court. So that is why you find that most of these cases fail, even though they are done by police officers. Somehow they don't understand a lot of nitty-gritties of digital evidence. So on this case, what came out clear is that anybody, the expert skill is not only confined to knowledge which is you acquire academically, but also skills that you acquire when you're doing that job and you've done that job for a long time. Now, some of the key skills of a credible expert witness. If you're an expert witness, know that you're going to present your report in court of law. So you need to perform thorough investigation, because if you don't do this, then you are going to be embarrassed in court. Make sure that you study all the reports that you need to study. You make sure that you survey the general body of relevant data. Make sure that you view all relevant objects of item carefully. Make sure that you conduct evidence testing. Perform very thorough investigation before you bring your evidence in court. Otherwise, you might be very, very embarrassed, especially if you get a very competent defense lawyer who is going to cross-examine you. And you know what they normally, their work, they are paid to make sure that they discredit you. So if you don't do a thorough investigation, know that you might embarrass yourself in the court of law. Demonstrate effective teaching ability. Now, you see, you have a knowledge, you have knowledge that not everybody possesses. This is a new area. Digital forensic is a new discipline. So if you go to court, you need to adopt that teaching kind of approach. You need to teach people. You need to make sure that the court staff, the prosecutor, the judges, the magistrates understand what you are talking about. You teach these people. You must be somebody who is well informed. You must be somebody who is well prepared. You need to demonstrate effectiveness in your when you're giving your testimony. So basically, what I'm saying here is that you are a teacher to that court. You are making the court understand why they should rely on your report. There's a time I went to court in Meru, and this case was about authentication of email evidence. Before they are actually admitted as evidence. These are exchange between two parties exchanging email. So when I went to court, because I needed to explain this how email work and how I can say that yes, this email actually came from this person to this person, I had to go to court with a projector and had to project everything so that I could explain one by one how things email works, so that the court will be able to understand and make a decision based on your testimony. So you need to be an effective teacher as an expert witness. You have to be competent in what you are doing, because if you are not competent, then please, you are going to embarrass yourself. So you need to have thorough knowledge of the field you are dealing with. You need to have appropriate experience, credential, or both. You need to make sure that when somebody is looking at your report, somebody is looking at your credentials, they can see, yes, this guy is really an expert. I've seen, especially on the prosecution, I've seen the report done by the investigators, and you see, you find that somebody says that I'm a digital forensic expert attached to the CID headquarters. Then you wonder, this person, that is the only statement they have not even put their CV so that you'll see what is the experience that this guy has, what kind of knowledge does this guy have. So you need, as an expert witness, when you are doing your report, this must be able to come out very clear, so that the person who is reading your report will be able to see that you are actually a competent person. You need to show that you have the ability to perform as well as teach the people, and you need to demonstrate the results. So being competent is very, very important a character to show in your area of expert witness. Be believable. Can people believe you just by what you're saying? Instead, you are not an advocate, but can you explain something so that people will believe you by what you're saying? Eh? Can the court rely on what you reach a conclusion on the facts that you give them? So you need to be believable. You need to persuade users of factual accuracy without advocacy. You need to persuade them without, you are not an advocate, but you need to convince them without arguing so much, because the facts that is coming from you will be able to demonstrate that, yes, this person is actually speaking the truth. And of course, you have to demonstrate enthusiasm and preparedness. So, rules of expert testimony. Now, each jurisdiction establish rules governing expert testimony. So, if we are in Kenya, there are rules that you need to adhere to, and especially when you are presenting digital evidence, you need to look at the digital, the Evidence Act. There are certain sections that you need to look at to make sure that when you are preparing your expert testimony, you adhere to those sections. Now, as an expert witness, you are expected to know the rules of evidence pertaining to expert testimony for the jurisdiction in which you are testifying. So if you are in Kenya, you have to know what are the legislation that I need to follow when I'm an expert testifying as an expert. When you're in the US, we have the federal rules of evidence. So each jurisdiction, this is not something that is custom, so it depends on the jurisdiction in which you are giving your testimony as an expert witness. And the general rule or practice is that the expert witnesses should be given the priority over other witnesses, because you possess knowledge that other people do not actually possess. So the evidence of such witnesses may also be challenged by other experts. Now, that is something that you really need to be careful. When you are doing your report, don't think that you are the only person in that field. There are other people who are also experts. So when you do a report and take it to court, know that the opposing side will also have their own expert who can also look and rebut your report. So you, as a lawyer, you'll get let's say you are a defense lawyer, you'll get the report from the prosecution that this is the report from the prosecution. Of course, it's going to be a technical report. So as a lawyer, you don't have actually to worry much. You need to get an expert, somebody like me, look at the report and look at the loopholes in that report, and now rebut that report. I do a counter report, and when I do that counter report, I can go and defend my report in the court of law. So just know that when as an expert, when you do your report, the possibility is high that the other party will also have the expert who is going to look at your report and is going to testify or rebut your report, or challenge your report. So, testimony of an expert witness. Now, a witness who is qualified, an expert witness is a witness who is qualified as an expert by knowledge, by skill, experience, training, or education, and is allowed to testify in form of an opinion or otherwise, if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine fact in issue. So you see, your testimony is going to be based on scientific or technical ability. So it is not, you need to make sure that what you are going to present to the court is going to help the court to understand the evidence and may be able to determine the fact or issue. Now, your testimony must be based on sufficient facts or data. And that is why, as a forensic expert, you are taken as an expert witness, and you are going to give your testimony, expert testimony. The testimony is a product of reliable principles and method. And the expert has reliably applied the principles and methods to the facts of the case. So this is why it is important when you are doing your investigation, then you do your forensic processes. Remember when we are talking about electronic or digital evidence, there were some characteristics that we say that digital evidence should exhibit before it is accepted in the court of law. There are some principles that you have to follow. So you need to make sure that you follow those principles. Then when you are doing your investigation or your forensic process, you also need to follow the standards procedures that are prescribed internationally. So that when you come to court, you are able to show the court that, yes, I followed some scientific or technical principle before I came up with these results. So because now that result is what the court is going to rely on when they're making decisions. So a testimony by an expert witness is very important in a court of law. Now, there are certain cases that have shaped this discipline when we talk about the expert witness, the testimony. Certain cases that have shaped the discipline. Now, one of the first cases is what we call the Fryer versus the US in 1923. This case is sometimes known as the first polygraph test. And it is one of the landmark cases that held remarkable relevance over the judicial forensics. Now, the defendant, Fryer, was convicted of second-degree murder instead of first-degree murder because there were a lot of confusion, and argued that on appeal that the trial erred by refusing to allow an expert witness to testify about the result of systolic blood pressure deception test taken by the defendant. Now, this guy shot somebody, and the case could not go on because there was nothing which was linking him to the crime scene. But later on, when he was caught on another crime, then he was questioned, and then he agreed that yes, he's the one who shot the other person. Now, what happened is that later on he denied. They say that now he did not shoot him, and then there was the psychologist, the doctor who invented the lie detector, went to the prison, and I think they did some lie detection using the polygraph test, and did some test on him. But when this guy was taken to court, the judge refused to allow the person who did the polygraph test to testify. Because why? Because it was held that the testimony about the systolic blood deception was properly excluded as at the trial because it had not gained required scientific recognition from this community. So what happened is that the court came up with a standard called the Fryer standard, and it was held that the expert testimony must be based on scientific principles that are generally accepted by the field of expertise. So why was the person not allowed to testify even though he did the polygraph test? Because at that time the polygraph test had not actually gained prominence in the scientific field. So it was only the case held that only expert testimony, which is based on scientific principle that is generally accepted, can be allowed in court. And this is the determination I quote. While courts will go a long way in admitting expert testimony deduced from a well-recognized scientific principle or discovery, the thing from which the deduction is made must be sufficiently established to gain and have gained general acceptance in the particular field in which it belongs. So this case is called established a standard called the Fryer standard, but it has yet been replaced by the Dobart standard. But what came out clear is that an expert testimony or an expert will testify only, it will only be based on scientific, generally accepted principles in a scientific world. Now, then came the Dobbert test in 1993. Now, the issue in trial was whether a prescription drug manufactured by the defendant had caused serious birth defect in children born of women who had used the drug. This is, Merrill Doe was a pharmaceutical manufacturing firm, and they manufactured a drug called Bendectin. And this, those women who took this Bendectin because it was a relief for the morning that morning sickness which happened to women who are pregnant. So those who took this drug gave birth to children with some defective deformities. But when the guy was taken to court, it was a very tough case because both sides came up with the experts, but to testify on this case. Now, in concluding that the trial court had improperly excluded testimony offered by the plaintiff because it was based on test tube and animal studies, which means that the plaintiff side said that this drug had effects on the deformities of the born children, but the other party was saying that no, it is not. This drug does not cause that effect. So it was the other part. The plaintiff testimony was excluded because their testimony was both based on test tube and animal studies. It was not based on the study of the effect on human beings. So the Supreme Court set forth some criteria that trial courts must evaluate in deciding whether or not to admit the expert testimony. Now, why this Dobbert test actually replaced the Fryer test is because at this time the rules of evidence 702 had come into place, had been drafted in the US. So they said that the rule 702, the evidence rule 702 is taking precedence over the generally accepted standards on Fryer tests. So the Dobbert test set another standard, which is mostly used by the courts in the US. Now, the court held that trial judges should be the gatekeeper when it comes to determining whether an expert testimony is scientifically valid. So it gave all the authority to the judges, to the magistrate, or to the jury to decide whether the expert testimony is going to be valid or not. Now, the judge in a case must consider the following 4 factors when determining whether or not expert testimony will be taken into consideration. Whether that testimony, whether the theory used is based on scientific and other specialized knowledge that has been seen, that has been tested. Now, when we are talking about forensic is a scientific principle. So when you are going, that's why when you are going to court and you are going to present any digital evidence, you have to tell the court how it has been collected, and that is why you need to use the scientific principles. You have to use the scientific methods to extract that knowledge. So, and the scientific method that you're going to use to extract that evidence must have been tested, and that is why you are considered as an expert witness. Whether the theory used has been subjected to peer review, whether the known or potential rate of error and existence of standard controlling the theory on operation, and the extent into which the theory is generally accepted in the relevant community. So the Dobat rule set precedence over the Freya rule. So these two court cases actually shaped the manner in which expert testimony is to be given. Now, as an expert, your finding can be challenged if it is not, if it is felt that you use methods and techniques that fall outside the generally generally accepted principle in your field. So that is why I'm saying that when you're doing your investigation, just know that you will also be subject your report to other experts who are going to look at your report. So you have to make sure that whatever you do is falling within the generally accepted scientific principle within your field. If such a challenge is made as to Dobat challenge or Freya challenge, a hearing may be held to determine whether your findings are acceptable within the established practice. Now, this is why when you are going to give your testimony, the other side will ask you whether you belong to certain certain societies or certain professional societies. Like normally in Kenya they will ask you if you are a forensic, do you belong to Computer Society of Kenya? Do you belong to Kenya Association of Cybersecurity and Forensics? So such things now, that is the community, your scientific community, that will be able to validate that what you are doing is actually following the established practices. Now, the judge will make final determination as to whether you will be allowed to present your finding or offer opinion in court as an expert. Now, the Dobat test case established what is known as Dobat standards now, and this standard is a test used in most of the cases in the US. Now, what are the roles of the expert? So the roles of expert varies, and there can be many roles depending on what you are doing. But now, an expert witness can be retained to review the forensic case documents provided to the retaining counsel through discovery of process, and to determine the following: whether the forensic analysis was done properly, can the forensic process be repeated, and can the forensic result be duplicated? Remember what we are talking about when you are doing your investigation, when you're doing your forensic process. You remember what we talked about in ACPO, the principle of the 4 principles in ACPO. What it said that when you are doing something, when you are doing your forensic investigation, when you are doing your forensic process, will somebody come and use the same principle and arrive at the same answer? Can the forensic results be duplicated? Is the examiner that performed the forensic analysis qualified? Now, this is important, because when you go to court, you'll be cross-examined to find out whether you are qualified. The person who did the investigation, the person who did the forensic process, are you qualified to do that? Do the forensic findings support claims made by the opposing counsel? So the thing is that as an expert, somebody like me, when you call me to work with you, I'll help you in a lot of things. I'll look at if you've been served by a report that that is incriminating your client, I'll look at that report. I'll look at whether the process was properly done, so that I can come up with my counter report. And then when I come up with my counter, I'm doing my report to discredit what the other party has done, including looking at the qualification of that person to find to question whether this person is qualified or not. For example, if you I did a report which I went to court, and the court was adjourned because when we went to court and the IO, I gave the report to the IO, then the IO served the report to the defense lawyer. Now, the lawyers just said, now, you are giving me the report this now and we are going to court. Now, it is not possible that this case can go on. So the lawyer prayed that the hearing be adjourned for another 2 weeks so that he could find somebody to look at the report and then come to court and defend that report, do a counter report. But then when we went back to court after 2 weeks, this guy got somebody who did not even understand the report that I did. So this guy was an IT specialist. He was not a forensic specialist. So this is where you can counter this, the person who has done the analysis, the person who has done the forensic analysis. Are you qualified? Are you a forensic specialist or are you an IT specialist? So these are things that you need to, as a lawyer, you need to be very careful. You need to know the guys that you are dealing with. You need to know their credentials so that you are able to sufficiently support your report. So it is important that an expert, as an expert, will always be able to help you through this process. Now, additionally, a forensic consultant will often help returning counsel prepare cross-examination questions for the opposing counsel witness, and they will usually be in court to listen to opposing counsel's expert testify. Now, this is also something that will help. Once I have done the report, I can also do what we call a leading questions that you can use now to help to question the other party, given the report that they have done. So from that report, you are going to look at is the way the report is done, does it follow the scientific process? And there are certain things that must be done when in a forensic investigation, so that when you look at the report, you are able to come up with questions that the lawyer is going to use during cross-examination. So we can always help you. That's one of the roles of an expert, to help you make sure that you can come up with those questions. Now, at the same time, you'll be in court, you'll be listening to what the other person is saying. If this person says something that is not correct, then you can be able to that. So the opposing counsel's expert testify to something that is misleading or inaccurate, the forensic consultant can be called to rebut the other expert's testimony. So you are there. I'll always be there in court with you. I'll always be listening to what the other person is saying. I'll always be communicating to you, but that please, apart for the leading question that we've given you, we'll always be there to look at, oh, this guy has said that, now you can ask this other question. Now, an expert may also provide technical explanation to the retaining counsel, a judge, or with regard to the forensic analysis and procedures. As I said, you are a teacher. You must be able to explain this technical explanation in a way that it will be understood by the layman. In this role, as a teacher or a technician, the expert will walk the interested party through many of the complexities associated with the forensic analysis. This is exactly now, this is where now you will see our work. This is where we'll help you to make sure that you tilt the case towards you, especially in both sides, whether it is defense, whether it is the prosecution side, but especially I find it is quite interesting when I go to court from the defense side, where this investigation has been done, and these prosecutors or the police, the CID guys have done their report regarding forensic investigation and brought their report to court. I find interesting because you'll find a lot of faults in that report, and that is why when I work, mostly the guys I've worked with have won the case. Those reports have been thrown out of the window because they don't meet the criteria. So when I go, whether the evidence is so incriminating, and I find it, I go to court and I find that it is not meeting the threshold. My work is just to make sure that that report is expunged, that evidence is expunged, that is not admissible in the court of law. Now, experts will often face highly technical questions when testifying, and the paramount expert receive up-to-date training in their areas of expertise, as they run the risk of being challenged if they don't actually update themselves. So you as an expert, we have a very, very tight in terms of updating your credentials, continuing education. Just like lawyers, you have to continuing education and earn your CPDs. The same thing like us, an expert in forensics. You need always to make sure that you are up to date with your qualification. You need to make sure that you know things that are coming, technical things that are coming in each and every day, you need to be conversant with, because this is a field that is changing very rapidly. Something that is new today, in the next minute, it is outdated. It's a rapidly changing environment. So you need to actually be able to make sure that you are not outdated, and lose, run the risk of being challenged in the court of law. There's a time I went to court and I was on the prosecution side. So after being direct examination by the prosecutor, it came to the time of cross-examination. So this lawyer did not, I don't know, he didn't even go through the report. So I was expecting the lawyer to ask me questions related to what I've done in the report. But the lawyer just resorted to trying to discredit me in terms of my qualification. I think he went to the website of my former university, where I did my forensic degree. And what he found out is that where by the time I was doing my forensic degree, it was called Master of Science in Forensic Computing and Security. But then by the time I was going to court just a few years ago, it was the university had changed the name of the course, and it was calling it cybersecurity, Master's in Cybersecurity and Digital Forensics. So this guy told, I looked at the website of this university and I didn't see this degree, which means that you are fake. You are not really a professional in this field. Then he looked at my certificate, because when you are going to, you have to go with the original certificates to show the court that yes, this is my actually my qualification. Then he looked at the other certificate I had for information security as an expert. Then the guy had nothing to ask. The guy was just asked, is this certificate in security recognized by the Kenya National Examination? And imagine, this is a certificate which is internationally recognized. So it really matters that when you as a lawyer, you need to understand these things so that you know exactly what questions you are asking, because you are not, you are supposed to ask the expert the questions according to the report that he has done. And if you have a smart lawyer who is also very smart in this field, then you will risk being declared as an outdated if you don't actually make sure that you are continually updating your skills. Experts should also be current with emerging trends within their fields. Now, scientific opinions and recommendation. Now, expert witness duty is always to be the truth and not to the individual who is paying them. Now, if you hire me as an expert, and I'll sit with you and I'll tell you, now here we are going to hit a snag. Don't try to tell me to bend the the facts to suit you, because that one, first of all, I'm going to discredit myself. Secondly, the court, when the court discovers that you are actually not telling the truth, but you are gearing your allegiance to the person who hired you, your credibility is at stake. So know that if something is wrong, my work as an expert witness is to talk the truth and confine my expert testimony on what I've found out when I'm doing the investigation. So they should always offer objective opinions and conclusions that are supported by facts and facts alone. That is what you are supposed to do as an expert witness. Your opinion that you are going to give to in court must be supported by facts and facts alone. So if you are asked a question, you are able to refer to your report, you are able to explain it with facts, and that is what is expected of an expert witness. Taking shortcuts during forensic examinations may lead to erroneous conclusion and ultimately result in challenge to the expert witness finding. So that is why, if it is a scientific principle, you need to use scientific methods of analyzing that data, because if you take shortcuts, you are going to get poor results or false results. And when you get false results, that is where you'll be at risk when the other party has got an expert witness who can be able to challenge you. So make sure that what you are presenting in court is actually something that is done in a methodical manner. An expert witness should never offer an opinion or conclusion if in court if they've not performed a proper examination of the evidence. Now, sometimes somebody calls me and then tells me that, yes, this is the report, and I want you to look at it and then do a counter report. And when you do a counter report, they say that I'm going to present this now in the court of law. Now, that is, you are running a risk of being report being invalidated, because what happens?
I'm looking at this.
Hello? Can you mute, please? So what you need, an expert, you need to make sure that the report that you present is based on facts and the methodical way of doing the analysis. An expert witness should never offer an opinion or conclusion in court if they have not performed the proper examination. So you need to do the perform that analysis in order for you to go and present it in the court of law, because you are going to defend it. You cannot go and defend something that somebody has done on your behalf. So it is you to do that, to make sure that the report that you present is actually done by you. So some of the roles and responsibility of forensic examiners, we went through this when we were doing the forensic report, forensic process, but I think it is better that we just know exactly what you are supposed to do. First of all, you need, when we talk about data identification, here is a case whereby you are identifying the computers, you are identifying the devices that contain evidence that you are going to do the analysis. So the forensic investigator must be able to identify all the location of such data, including metadata, that is data about data. Something like when you have a picture which is graphic has got what we call metadata, what we call the EXIF data. That is data that is talking about that particular graphic. For example, the date of creation, the type of application that it created it. If the GPS was enabled in that form, then it'll be able to give the location. So things like that. Then the investigator must balance the needs for speed, thoroughness, completeness, and accuracy. Then data acquisition. This is where you have you've got your devices, and now you are acquiring the data from or evidence from that those devices. Now here it is important to note the process of acquiring that data, because this is something which is will be challenged in court, because if you don't use a scientific method to acquire that data, then that data, the integrity or authenticity of that data is going to be questionable. So it is important that having identified the relevant evidence, the investigator must acquire the evidence in a manner that preserves its integrity and admissibility. Now, this is where the evidence that you bring to court is going to be thrown out, because if I can come and rebut that and say that you did not use the proper way of acquiring this evidence, then that and the court, I can prove to the court that that evidence has no integrity, the integrity has not been preserved, then that evidence is going to be thrown out of the court. Then the forensic investigator determines which tools, techniques, processes which are likely to extract that. You remember that when you go to a forensic scene or to a crime scene, what you need to do is look at, first of all, you identify the data that the devices that you need to collect. Then with that, you'll be able to know which tools will be used to extract that data, because when I talk about the mobile forensics, it is different from computer forensics. So the methods and the tools that I'm going to use to extract data from a mobile phone or a tablet is quite different from the techniques and the processes that I'm going to use to extract data from a computer or a laptop. So you need to make sure that you understand that. Authentication of the data. So one of the most important roles of a forensic examiner is to be able to authenticate electronic or digital data. Now, authentication is very important, because authentication is the process of establishing to a relevant legal standard that the evidence is what it purports to be and have not been altered or modified. Now, if you are going to court and remember the other party, if you are they have very skillful expert on the other party, these are the things that they are going to dwell on. The authentication. How does the court that data that you are presenting, that digital evidence, that it is reliable, it is authentic? So these are things that we as experts, if I'm either on the prosecution or on the defense, these are things that we are going to dwell on to make sure that we actually discredit the evidence that you have brought to court, so that it is thrown out. So part of authentication involves completeness. That is, if you can testify that a file contains all the emails between parties, then you have to establish a process of establishing that fact or assertion. Last time I was telling you how I authenticated an email, because this somebody can say that no, it is not me who sent that email, because email can be spoofed. Now, how do I authenticate that email that has been that has been printed on paper? I go to the electronic mail. I look at certain features called headers, and then extract the useful information that will be able to tie you to that email. So that and then I can be able to testify that the process is okay. Now that is what data authentication. Then you analyze that data. That is what is required. What is acquired during the course of investigation is raw data and mere data, such as files, documents, and spreadsheets. So your work as a forensic investigator is to collect data from numerous sources, harmonize that data, and then you duplicate that data and make sure that when you analyze the data, you come up with the results that are duplicable, can be duplicated. Now, presentation of that evidence, ultimately the goal of the computer forensic is to present the relevant evidence collected before the finder of fact or decision maker whether this is a general counsel or prosecutor or judge or someone. Because what you are going to do is just, once you've done your analysis, you are going to present that data. You are going to present that data in terms of a report, in terms of maybe you'll ban a CD to bring to court as an evidence, and then that CD will be accompanied by a report and a certificate. Remember the cases that we are looking at that have been thrown out because of lack of certificate due to section 106B. So you present that data to that report to the court, and the court will be able to make a decision depending on that report. Now, the evidence collected should be presented in a manner that ensures that it is its integrity and admissibility, and enhances its understandability and improves its clarity. So in the issue of integrity will actually affect admissibility of that evidence. So and my work, if I come as an expert witness, if it is me that has done the report, I know very well that the other party will always try to discredit my report and get it inadmissible. The same way, if I'm studying a report that has been done by another person, my intention is to make sure that I render that report useless. I render that report, I discredit that report, and I tell the court that my opinion, this report is inadmissible in court of law. So you need to do your report writing. Then reports should be written in a plain, clear, and basic language to avoid ambiguity and misunderstanding. Remember, what you're doing here, you are not addressing technical people. You are addressing professionals in their fields, and what you are doing here is to make sure that the report that you are giving them can help them make a decision. So it is important that report that you are going to do, make sure that you do not use jargons. You use a plain, clear, and basic language, which make sure that there is no ambiguity and people are going to understand your report. Without that, then you are going just to be a technical person to the court, and your report will not be understood. When your report is not understood, then it means that you've not helped the court to make a decision. So all supporting documents associated with the case, such as logs, handwritten notes, template, should be maintained in one central location. So you must make sure that when you go to court, because you are going to be asked so many things by the judge or by the other side, must make sure that whatever they ask, you have it. Anything that relates to the investigation that you did, you have it, so that any question that they bring to you, you are able to answer. So some of the aspects of a good report. A good report achieves the purpose by answering the questions that were set out in the mandate for investigators. This is a case where you are hired as an investigator. There's a certain thing that the guy who has hired you wants from you. So the report that you are going to get to them must be able to answer those questions. It is designed to meet the needs of the decision maker, which means that the person who is going to make decision is going to rely on that report to make the decision. Now, a decision maker must rely on the facts that were presented in the report, and the facts must be based on evidence on file. Now, it must be written in a neutral language so that the decision maker and other readers will be able to understand it. This is what I've emphasized on the last slide, where I said, yeah, the report must be able you have to make sure that the report is something that can be understood by everybody who is the audience of that report, the recipients of that report. It should be concise and must convey the necessary information, and it should be structured in such a way that information can be located so easily. So that you must make sure that your report that you are going to do, the report that you are going to present to the court, is actually understood by your audience. Now, bearing demeanor and appearance in court. As an expert witness, the impression you make to the judge and the jury is critical to establishing your credibility. Your demeanor in court needs to be to remain professional throughout your testimony. I mean, here is a case where you are a professional, and you must make sure that you impress the court, and the court can be able to believe in you. It is never wise to be sarcastic or unprofessional during testimony, as this type of behavior not only diminishes your credibility as an expert, but also disrespects the court. Now, one of the things that I've found out with lawyers, especially when you're being cross-examination, is to tire you, to make sure that they make sure that you go out of your way in your presentation. So as an expert, you should never engage in aggressive attorney with aggressive tone on your part. As to do this will only distract you from the important, what is important, what you've come to present, that is your testimony. So sometimes the defense lawyer will ask you some questions which sometimes you find they are silly, but you don't have to respond in a way that is going to show that you are worked up. You can remember, with due respect, when the interviews for the Chief Justice was being done, I can remember when they were in interviewing Justice Ojwang. Then they was asked some question and the guy got worked up. Now, that is what exactly when you go to court, the opposing side, whether it's the prosecutor or whether it is the defense, that is what they want from you. They want you to get worked up, and they want you to distract you from what brought you to court, that is your testimony. So you have to be very careful when you're dealing with this, guys. The other thing what you need to look at the code of ethics. Now, ethics means moral, showing moral characters, and has alternatively been defined as a custom or usage. Modernly, ethics is understood to be professional, not shared by a group on the basis of mutual and usually reciprocal recognition. So if you are in the forensic world, you subscribe to some code of ethics that is used in that field. So you must make sure that you maintain the code of ethics in your area of practice. So ethical decision making in cyber forensic work consists of one of the following: be honest, prudence, compliance with the law, and professional norms. So the need for ethics in digital forensics. Now, the relatively recent and rapid evolution of computers and information system has resulted in novel capabilities to store, retrieve, and process information. In just a few years preceding to this writing, new fields of expertise such as ethical hacking and cloud forensics have emerged, all of which have added to huge demand of highly educated specialists in discipline of digital forensics. So it is something that is really expanding very quickly, really developing very quickly. Some few years back, we did not have cloud computing, but now we have cloud computing. So which means that some few years back, when you go to a place, you collect the computers, you collect the laptops, but nowadays you go to a place and there's no laptops. The laptops are there, but the laptops do not even have a CD. The laptop do not have diskettes, and the data is not stored on that laptop. The data is actually stored on the cloud. So you see how rapidly this field is changing. So it is important that you as a digital forensic specialist, you make sure to always be ahead of in terms of knowledge. So codes of ethics have other interests, including presenting an image of prestige and credibility for the organization and the profession, eliminating unfair competition and fostering cooperation among that particular community. Now, some of the best practices that you can follow when you are talking, when you go to court. First of all, when you know that you are going to court, be on time for all court appearances. Make sure that, yes, you don't reach there when the proceeding has started. No, people, the magistrate will even look at you and see whether that you are not. Dress in a manner that shows respect to court. Go over your report and underlying evidence again just prior to testing. Just make sure that what you are going to present, you actually know it inside out, so that no question is going to come out from that report that you cannot be able to answer. Listen to each question and make sure that you understand it prior to answering. So make sure that you listen attentively. If counsel is attempting to get you to answer a complaint question with yes or no, it is your right to explain your answer in order to make it accurate. This is very common with lawyers. They ask you a question and then you try to explain, then they say, no, please, I just want a yes or no so that we can continue. But then please, if it is yes, you can say yes, but make sure that you are allowed to explain. Because sometimes they just say, trick you with a question to make sure that you say yes, so that they can use that to discredit you. So you must make sure that whether it is a yes or no, you need to, if it is something that you need to offer explanation, make sure that you appeal to the magistrate that you need to offer the explanation, and you'll be given the opportunity to do that. If counsel voices an objection, sit silently until the judge has ruled on the objection. So these are some of the best practices as an expert witness when you go to court. Now, do not speculate. Do not give answers that you are not pretty sure about. So it is always, if you don't know, just say, I don't know. It is not a crime to say I don't know. So, but don't try to juggle around trying to explain that something that you don't know. So if it is, and make sure that here you are an expert in your field, and if you are juggling around, the guys are studying you and to see whether ways in which they can be able to discredit you. In general, do not volunteer information that is not asked by the question, because you can volunteer information that will actually turn against you. So make sure that you do not volunteer in information that is not asked by the other party. Always tell the truth, whether it hurts or helps the other side that you are you are testifying for. This is what I say. It does not matter. Your allegiance is to the truth and the truth alone. So make sure that whatever you're saying is only the truth, and that does not matter. So these are some of the ethical dilemma that we run on, because sometimes the guy who hired you think that you should say something that is going to be tilted towards their favor. But here, you remember, you are an expert, and your expertise is based on the truth. The truth is what you are going to talk to the truth, and just confine yourself within the report that you did, and that report actually is based on the investigation that you did. And that investigation, you just have the facts and facts alone, and that is what you confine yourself in. So don't try to make the other side party because they hired you. Your allegiance is to the truth and the truth alone. Competent counsel will always meet with his or her witness ahead of time, freely admit that you have done so. Just make sure that before you go to court, it is always good to meet. Always good to sit down with the counsel. It is always good to talk about review the report, look at the leading questions that you are going to tell the lawyer to ask during cross-examination, so that you understand each other. Don't go to court then it ends up in a confusion, like you are not in sync with the lawyer. So it is important that you guys meet ahead of time to make sure that you clear some of the questions that might arise. Be cautious, courteous, and respectful to your responses, even if they feel that you are being pressured. Just don't always answer in a way that is showing some disrespect to the court. Just make sure that your answers are very respectful, and you are able, even if you are given put under pressure, just make sure that your responses is respectful both to the court and at the same time to the person who is actually cross-examining you. So if we look at a summary, what we've looked at today, we've said that an expert witness is a person who has thorough knowledge of a subject and whose credential can convince others to believe his or her opinion on what the subject in a court. Now, so this is what an expert is all about. You have a thorough knowledge on the fact of the matter. You're a teacher, and your role as an expert witness is you must investigate the crime and do thorough investigation, as we said. You have to evaluate the evidence before you present those evidence in the court. You have to educate the public and the court about what you are doing, and then you have to testify in the court. So, and the role of an expert witness in bringing evidence to court is to assist the court in understanding the intricate evidence. Here we are talking about things that are foreign to the court. So you are the expert, you are the one who has got understanding, and you are the one who is going to be able to educate the court in order to understand the evidence that has been brought to court. Now, you also need to aid the attorney to get the truth. Work with your attorney, work with your lawyer to make sure that what you are going to present is the truth and the truth alone. Then truthfully, objectively, and fully express his or her opinion without regard to any views or influence. This is what I say, that do not, your allegiances to the truth and the truth alone. Do not base your allegiance to the person who hired you. Just make sure that you talk the truth, whether the other side, that hired you is being hurt, but the truth is what you are talking about. That is going to save you in terms of your credibility. When you are testing in the court of law, in the courtroom, presenting evidence in court requires knowledge of new, specialized, evolving, and sometimes complex technology. You see, here you are a technical person, and you are coming to educate the court. Now, you need to familiarize yourself with usual procedures that are followed when you're during the trial. So the attorney introduces the expert witness with high regards. Always, the person, the lawyer who hired you will always make sure that they put a lot of salt and sugar in your credentials, so that you are seen as somebody who is really an expert. So if you've been introduced as in that high regard, and then you are asked questions which are simple and you cannot be able to answer, you really put your credibility at risk. So the opposing side may try to discredit the expert witness. This is what I've said. They will always try to discredit you. They will always try to throw out the evidence that you presented, and make sure that you are somebody who is useless, somebody who is a quack, somebody who does not really understand what they are doing. And that has happened to me. I've told you that that has happened to me, whereby the other attorney, the other opposing side wants to discredit me and telling me that I don't deserve giving my evidence because I don't have the right qualification, I don't have the right evidence, credentials. So they will always try to do anything to discredit you. So the attorney would lead the expert witness through the evidence. That's the examination in chief. Then later on, it is followed by cross-examination with the opposing counsel. So you just need to know the order so that you are well prepared. Closing the case, the investigation should include what was done and result in the final report. Your report should include everything. Don't leave anything, because you see, when you once the report has been submitted and registered in court, then what you need to know is that that is the report that the court is going to rely on. So you need to include each and everything in that particular report. Basic report should include who, what, when, where, and how. In good computing investigation, the step can be repeated and the results obtained are the same every time. This is what we looked at in the forensic process. Are you able to duplicate the results? Because remember what we said when you are doing an investigation, never work on the original evidence, because the best evidence is always the original evidence. And that is why you are doing a bit stream or duplicate bit by bit copy of the original, so that in case the opposing side says that no, we are not satisfied with this report, so give us the original evidence, then we can also be able to do our investigation. And when they do the investigation, then they should come up with the same result that you came up with. The result is able to be duplicated. So the report should explain the computer and the network processes and the inner working of the system. Now, this is where I normally discredit most of the reports, because when the report, I look at the report, like what I find out is that the explanation of the process that was used to acquire the evidence is not there. And this is even according to the law, the Evidence Act that we have right now. It prescribes what the condition that must be met by digital evidence for it to be admissible. So the report should be able to explain the computer and network processes and the inner working of the system. And you have to declare that, yeah, when I was doing this, the computer or the device that I was using was actually in good working condition. So the investigator should provide explanation for various processes and various interactive components. So you need to make sure that, yes, every little thing that is supposed to be in the report is actually explained properly, and everybody is able to understand your point. I think that brings me to the end of my report. I've talked about the professional conducts, and we looked at that. You need to consider the code of ethics in your area of specialization. So follow the criteria to maintain professional conduct. You need to look at the credibility, ethics and morals, standard behavior, maintain objectivity and confidentiality, enrich technical knowledge, and conduct yourself with integrity. Also, chain of custody. Make sure to bring your report to the court. That chain of custody is maintained. That chain of custody will always be detrimental to your testimony or to your report when it is missing, because it's a log document that will accompany the digital report, the digital evidence when it is presented in the court of law. So with that, I think I come to the conclusion of my presentation, and I'll get back the mantle to David to continue. Or the chairman. Sorry.
All right. Thank you so much, Lawrence. Thank you for that wonderful presentation. I see today is one of those days where your presentation has attracted very, or rather no questions. I am wondering whether it is because we have understood everything or because we have not understood anything at all. But from the clear manner in which you made the presentation, I think we appear to have quite understood a lot of what you have said. Maybe I could just ask that one, you give us your contact, your telephone number, and email, so that in the event that any advocates intend to contact you, they're able to do that. I know the presentations are going to be shared, but I think it's critical that for those who can get that, your contracts are able to get them.
Yeah, I think my contact are there. Yeah, you can see my contact is there. The telephone number. My email is lding@managecom.co.ke, and you can reach me.
This one doesn't have your telephone number, unless I'm the only one who is unable to see it.
Down there, can you see? Down there, you can see. There's my telephone number down there.
No, it's not here. It's not showing on the screen.
Okay, but I think when you are going to share this presentation, it's going to come with the telephone number.
All right, I just thought that for those who can get it here, you know, sometimes you share these things and people don't go through them.
Okay, so how do I put it on text here? Can I do? Let me just.
Why is it that I'm the only one who's not seeing it? I can see someone else saying that it is showing.
It is showing. It is showing down there in that first the first presentation. Down there, there is Lawrence Dinga, then the telephone number, and then there is the email address.
All right. As now that the members confirm that they can see it, I think I am happy, because those are yes. I think even on the chat it is showing. All right. The other thing I wanted to perhaps ask is from your interaction with the advocates.
Yes.
In court, what do you think are the common mistakes that advocates make during trial? That is on both sides, when they are leading evidence by an expert. And
okay.
During cross-examination.
So, all right. I think
I could ask another, so that we take like probably 5. The other would be, how is an advocate, or what would be the best way for an advocate to either to lead evidence of an expert, especially when that expert testimony contradicts the report of another expert, so that the report are contradicting? Then how do you lead that evidence? And then what would be the best way? How do you would you advise your advocate then to prepare for cross-examination in those instances. Stephen Saini has asked a question. How effective is the counter report? I think he says some courts have dismissed reports saying they were made when data was stale and are merely meant to discredit the original report. I'm not really understanding his question, his explanation, but some courts have dismissed some reports saying they were made when data stale and were merely meant to discredit the original report, saying you did not present your own report. So if you can make sense of that. Jean Marie is asking, who is required to know a lot about the case, the domain of the case, the most important aspects of the case? Is it the expert? Is it the advocate, or is it the judge? Sandra is asking whether Kenya has made any steps towards considering the use of polygraph testing as part of interrogation practices. So maybe you can answer those and then I can go into the chats. I see if there are some more questions.
Okay. Now, the first question of some of the mistakes that advocates make during direct examination or cross-examination. One is, what you need to understand as an advocate is, first of all, work with your experts. Because you see, you are not the expert in this way, you are a lawyer. And what has been presented here is the digital evidence, and you are not a forensic expert. So what you need to do is that you understand, sit down with your expert and understand the report that the expert has given you. And if he's a good expert, what he'll do, apart from the report that he has given you, is going to help you with leading questions, which you are going to ask during a cross-examination or direct examination. Because if he's not able to give you that, then know that that's not a good service in term when I consider the service that we render. Because I'm there to help you understand the report. I'm there to help you to make sure that the questions that you are going to present is valid and coming out of the report. So the mistake that most of them do is that they don't find the best expert, and then they don't go through the report. Now, if you don't go through the report, then it becomes difficult for you to answer the questions that formulate questions or questions that you are going to ask. I gave you an example that I did a report and I went to court, and then I handed the report to the IO, who handed the report now later to the defense lawyer. Now the defense lawyer looked at the report. It was only a 40-page report, and then when he looked at the report at that particular time, when the court was starting at 8:30. Now, he prayed that because he did not have the time to look at the report and did not have an expert, he prayed that the court be adjourned for another 2 weeks so that he can go and study the report and even get an expert to come and help him in court of law. So after those 2 years, I went back to court. And I was expecting that now this guy has understood the report, and he even came with an expert to court. And the mistake that he did is that he did not come up with a forensic specialist. He came up with an IT specialist. So who did not even understand what I had put in the report. So when this guy was cross-examining me, as I was expecting that is going to ask me things that I've done in my report, because that is, it should be confined to my report. The guy could not ask me even a single thing from my report, which means, first of all, he got the wrong guy as an expert. Secondly, he did not go through the report so that he could formulate questions to answer. And thirdly, the expert that he got did not help him to create leading questions that he could ask me. So the guy was just dwelling in trying to discredit me in terms of my credibility, asking me when did I do my degree, and that degree is no longer existing in that university, and so I faked my degree. The other thing was asking me about my international cybersecurity certificate, and asking me whether that certificate is recognized by the Kenya National Exam Council. So you find that the kind of question that he was asking could not even help him in terms get any information from the report. So that is one mistake that you need to avoid. You need make sure that you sit with your expert and is going to help you come up with the questions that you need to ask. That is the service that an expert should be able to do. Remember, I said during the presentation that one of the duties of expert role is to help the attorney formulate leading questions for cross-examination. So the thing is need to sit with your expert and need to understand the report. So the best way to lead evidence when the reports are contradicting. Now, what you need to understand here is you are an expert. You are not a lawyer. You are helping the lawyer to understand the complex scientific or technical issues regarding the evidence that has been brought. That is the digital evidence. So what happens that when you are going to, what takes you to court is to present your report. And if the report contradicts, then one of the experts is not talking the truth. And remember, what you need to do is your allegiance is to the truth and the truth alone. So if the reports are contradicting, which means that you look at the process of the forensic process. Did this person who did the investigation, did he follow the laid down scientific principle to come up with the results with the data? Can this data, came up with the evidence that they came up with, can we follow the same forensic process and arrive at the same results? So if we cannot be able to arrive at the same result, then somebody will be able to is actually not telling the truth. So what's happened is that if it is contradict, if it is you which contradict, then I think you are not you are not an expert. But if you follow the laid down scientific procedures, then you need not to be afraid, because you know exactly what you're doing. You are an expert in this field. So still here you are going to help your lawyer, because before you go to court, these reports must be exchanged so that you actually know what this person has done. But you see, remember, the conflicting report will only come if the other side has done their report, and then you come, you cannot be able to understand it, so you hire another expert to understand that report and come up with a counter report. Now, the counter report, always when I do counter report, what I do, I do not necessarily object what the other person has said. What I'm looking at the process of how this guy had arrived at the report. Is he following the scientific principles that are laid down when you are doing forensic investigation? Are they followed to the letter? And wherever there's a loophole, that is where I highlight, and that is where I dwell on, and that is where I try to convince the court that that report that is put before them is not worth, is not admissible, because the laid down international principles are not followed to make sure that they come up with the evidence. So the evidence that is brought to the court is questionable. Now, how effective is the counter report? Now, the counter report always, I make sure what my intention of countering the report is to make sure that the report that you did, I'm trying to convince the court through lay down scientific procedures and methods to tell the court that you actually your report is your evidence is not admissible. See, that's what I'm going to court to do. Like right now, I have a case which is coming, and the prosecution has brought has done their report, has brought the report to court. Now I'm going there. What I have done is that I've just done my counter report. I've looked at the report that the prosecution have done, and I've seen a lot of loopholes. So when I go there, those are the loopholes that I'm going to highlight to the court. And the end result, my opinion is that this evidence that is brought to the court does not meet the threshold and should not be admissible. That is the function of a counter report. And if it do it properly without biasness, actually the court is going to consider it and will actually throw the other report or declare it admissible if your facts that you placed or you put in your counter report are effective. So who is required to know the domain of the case? Of course, it is the lawyer, because you are not remember what you are going to do is you are going to do the investigation. After doing the investigation, you are going to present your report to the lawyer, and then you go to court. It is the lawyer who is going to who should know the legal aspect of the court. You are a technical person, so and that's why you do your report and you go with the lawyer to the court to help him understand the technicality in terms, the scientific principle around the digital evidence. It is not you to look at the legal aspect of it. It is not you to make a decision for the court. Your work is to render your opinion, scientific opinion, but not to a legal opinion. So the lawyer is still the guy in charge, but you're helping the lawyer to understand the technicalities and the scientific principle around the digital evidence. Somebody is asking polygraph test whether it is allowed. Sincerely, I don't know, but I understand that it is always used in. I don't know whether the DCI has got the polygraph test, but sincerely, I don't know whether it is used in Kenya. Any other question? I think I've answered all the questions. Back to you, Eric.
Yes, indeed, you have answered the questions we posed. Thank you so much. I can see there are about 3 other questions. There is a question on, this is asked by an anonymous person, and it is not surprising that they are asking about things that are best in the clouds. So the question is, how do you effectively examine and present evidence that is based on the clouds. And then Saini is asking, is there a Kenyan case highlighting the same requirements as the Fryer and the Dubert test? And then there's the other question on are the digital forensic international principles recognized in our Kenyan courts? Have they been domesticated or anchored in any legislation? I think those are the only other questions that are pending, and if you can answer those, I guess we will have exhausted all the questions that have been posed for you.
Okay. How do you effectively examine evidence from the cloud? I think we covered this in forensic process, where we highlighted that, yeah, the cloud has changed things, and nowadays you don't actually. Sometimes you go to a place and you carry a computer and you don't find any data in the hard disk. Then the data is in the cloud. So what I can say is that it is not is a matter when you're talking about presenting that evidence. What you need to ensure that the evidence is authentic, the evidence has got integrity, and the process of collecting that evidence is not questionable, and it is transparent. That is what the court will need to know, to make sure that the admissibility of that, to ensure admissibility of that evidence. So we all talked about some characteristics that an evidence must be exhibit to make sure that it is admissible in the court of law. And that is what I said: the authenticity of that evidence, the legal authority to acquire that evidence, the relevance of that evidence, the credibility of that evidence, including the person who is collecting that evidence is he qualified enough? Does he have the correct credential to collect that evidence? Is he a specialist? And of course, the integrity to show that that evidence has not been changed in any way before it was presented to court. So there's a process of collecting evidence from the cloud, that is the cloud forensics, which we cannot be able to discuss now. But just make sure that when you collect it using the proper process, it exhibits the characteristics that is going to make it admissible in the court of law. Now, the other thing is about a case highlighting the Fryer and Dubert case. I'm not aware of any case about that. The reason why I brought these two cases is that they actually made some significant relevance in terms of judicial forensics. And they have been, mostly they are in the US, and you see, as US is the leading in terms of this technology, the Fryer case was based on the generally accepted principles in the scientific principle. So, and Dubert case was derived to which actually superseded the Fryer case, and it was derived after the case between the Dubert and Merrill Doe, and it also it expanded the Fryer case in the sense that it allowed a lot of technical scientific innovation to be admitted in court of law. So, and also taking into consideration the federal rules of evidence 702 that made up the debate standard. So these cases are mostly used in referred to in the US. But I believe that when you are talking about a scientific presentation of evidence or evidence derived from a scientific method, that is taken care of. You can quote these cases, but also in Kenya, because they're international, because they are based on the scientific methods of deriving the evidence. So I don't know any case that is based on this, but there are principles that are used internationally. But of course, in Kenya, we have the Evidence Act. If you go through the Evidence Act, it will tell you how you are supposed to present these cases. So as I say that the expert testimony and the presentation of this evidence is based on the jurisdiction in which you operate. So Kenya might not be able to use the Fryer and Lubert test, but will base our presentation on our local legislation, which is the Evidence Act. It has got all those clauses which talk about presenting evidence that is derived by scientific method. Now, we are talking, somebody is asking about our digital international forensics, international recognized in our Kenyan court. Of course, I mean, if you look at the Evidence Act, look at section 65 and see what is talking about computer printouts, okay? Look at section 78A. It talks about the messaging information, evidence derived from WhatsApp messaging and how they should be presented. And then look at the section 106B. It gives you how that evidence should be presented in court. But now they don't talk about the digital forensic process. They don't talk about the principle. They are talking about how that evidence should be presented. And of course, for you to present that evidence in a manner that the court is prescribing or the legislation is prescribing, or you'll have to follow the due scientific process to come up with that digital evidence so that it meets the qualification according to those sections. So of course, the digital forensic principle is recognized in our law in Kenya due to how the local legislation wants us to present that evidence. You'll have followed the basic principles, scientific principle to come up with that digital evidence. Yeah, I think that I hope I've answered that.
Yes, indeed, you have, and accept our sincere gratitude and appreciation for the 3 sessions that you have taken us through. I think from the comments I can see people who have, participants who have joined us for the last 3 sessions, actually confirming that they have left this forum much informed, and they have learned a lot. I think I can see a comment from Eric Kinyua who says that I've been present in all 3 presentations and I must say I learned a lot. Good job. So that is the general feeling and the general appreciation of our members who have managed to join this, and even those who have joined from across the borders. And we want to thank you so much for the very insightful and very engaging presentation that you've given us. I'm sure once we get the slides, we would be interacting much more with that information, and that would be better off when it comes to presenting, and also questioning evidence, forensic evidence, whenever we come across it within our practice. So thank you so much for that. Thank you, the East African Law Society, for partnering with us on this very, very novel and very interesting subject. We appreciate that. And I think, David, I want to now give it over to you to close it. I think it would be remiss of me if I don't thank all the lawyers from the Nairobi branch who have joined us for the 3 sessions, and those who have also just joined us today. The information or the other sessions would be available on YouTube and also on email, the slides. So thank you for joining us. And David from East Africa, you can tell us how things are across. You know, your jurisdiction is wider than ours. So thank you, and have a nice evening. David?
Well, thank you, Chair. Thank you to Lawrence for taking us through all these 3 sessions. I think they have been eye-opening to myself and to many advocates who have taken their time to be on these forums for about 6 hours. I think 6 good hours, 2 hours of your time, 3 times. So we thank you all. I will be sending the presentations, as always, to your emails. Everyone who has registered, I think I have your emails. So we will be sharing those presentations through those emails. Lawrence is open and available for further consultation outside of this forum. So should you have questions, should you have digital forensics matters to be handled, I think Lawrence is available and will be willing to offer his services beyond the borders of Kenya. Chair asked about matters beyond Kenya. I think East Africa is doing well. Some countries are corona-free, as you might be aware. And I think things are starting to look upwards. They're starting to look good. We're having physical meetings. Actually, there is an East African community meeting right now that is actually one-on-one. So it appears that we are now opening up, and we are hoping that the same happens for Kenya, so that we have these trainings on a one-on-one basis. That way we can easily network and exchange contacts and work together for the future. Our CEO is unable to join, and so is Barbara. She is indisposed today. She has sent her apologies, so I send them to you on her behalf. But she says she's very happy with everyone who was on this platform and participated and contributed. And we look forward to having you in the future. Actually, not very far from today, on 27th, we are having a training on drafting of pleadings before regional courts. So it's a sort of masterclass, and we'll have experts from Kenya, Tanzania, and Uganda on this particular session. So we will be sending out the call to express interest in attending the training. So if you're interested in having a go at the regional level, that is the East African Court of Justice or the African Court, then this is a training for you. It's happening on 27th of this month. The time is slightly early, 11 a.m. to 1 p.m. But details of this will be sent to you. I have nothing more to add. I don't know whether, Mr. Chair, you have anything, or Lawrence, you can give your concluding remarks, and then we officially end this session.
Oh, thank you, David. I think, first of all, I want to thank everyone who has participated in this training. I think it has been an eye-opener, and this is a new area that is coming up very rapidly. So I'm here to work with you somebody asked me my email address. I put my email address there, ldinga@managecom.co.ke. So in case you have any issue, any case that is involving forensic investigation, I'm always available, and you can catch up with me. I can help you do the investigation, do the report, and then present that report in the court of law. And or sometimes maybe you have you are a defense lawyer, and your client has been charged, and the information involved digital evidence, and you've been served with a report from the prosecution. You can call me. You can I can look at the report. We can work on the report. We can look at the loopholes within the report and help you do a counter report. I'll also go to the court to defend that report, and we'll work to make sure that we take advantage of the loopholes for the report to be inadmissible. So I thank you very much again, everyone, for attending this, and I hope that we are going to work together in the future. Thank you so much. You are muted, David.
Sorry. Thank you, Lawrence. I'm asking whether our chair has any final comments.
No, David, I've already made my closing remarks. I just want to wish all the participants a pleasant evening. And yourself and Lawrence.
Thank you. Have a nice evening too.